candidate wouldn't have been at all allowed to participate at all. Now, maybe. Well, I am. One thing, my lord, when your lordship is considering the question of public employment, my lord, this is not a one-to-one issue. This is issue of, my lord, whole recruitment process being conducted, my lord, following the principles. Now, here, lordship will kindly, what the state government's, my lord, stand is, as I understand, my lord, from my juniors, that there was an amendment of law in 2017. Kindly takes up that amendment. Look, this is a part of, I'm told, compilation by one of my learned friends.
আরেকটা বই নেই তোমাদের কারোর কাছে রাইট টু একটা বই আছে লজিক্যাল
This is very important, amendment of law, which is the probable defense of state.
এটার থেকে পড়ছেন তো এই জিনিসটাই কোর্টে দেওয়া আছে অন্য একজন কাউন্সিল দিয়েছিল সেটা বলে দেবেন
কোথায় আছে
সাগর বন্দ্যোপাধ্যায় সাগরদা দিয়েছিল পেজ নাম্বার 1 ওটা দেওয়া
but I am told this is a part of the compilation filed by Mr. Sagor Bondopadhyay.
23 was argued.
not 23
Kindly come to 2017 amendment of the act.
সাগর বন্দ্যোপাধ্যায় কে আছে
এই কম্পাইলেশনের মধ্যে আছে দিনদাস
না না এই বইটা আছে এই বইটা
আরে কম্পাইলেশন তে এই কম্পাইলেশন তো দেখি
জজ সাহেবরা কম্পাইলেশন থেকে সুবিধা হবে
No, it is there with us.
kindly may I just place it, Lordship will immediately get it.
This section 23.
No, this is the
23
amendment of Right to Children Pre-Education Act.
section 23 provides second provides
Which paragraph you are reading?
That it shall be deemed to have come into effect on the first day of April 2015. That is the retrospective effect given. In 2017, law is made. Retrospectivity is from first of day of April 2015, not beyond that.
Where you are reading?
That I am reading, kindly come to section 1 of the amended act.
স্যার ওখানে পাবে না অরিজিনাল একটা প্রিন্ট করা
তাহলে কেন ওটা দিলে জজ সাহেব যে বুঝতে
তাই তো বলছি
ওটা এটা বের করছো
আমি সেটাই তো আপনাকে বলছি স্যার
ওইটা কম্পাইলেশন বার করে দিতে
বার করতে বলছি আপনি
What you are saying, Mr. Das?
that book will not really reflect that.
ওটা আপনি বলে দেন আপনার হাতে
So may I read out for your lordship?
স্যার না স্যার এখান থেকে আপনার পুরো দর্শকরা
কোনটা দেবো এটা মার্ক করা
ও স্যার
কি যে করো না
স্বাগত
এখানে সাগরদার কোনো সাগরদার যে একটা কম্পাইলেশন দিয়েছিল যে কম্পাইলেশনটা দিয়েছিলেন
So, order to keep this as your next argument.
yes so I'll just give the point.
You have already mentioned to us that on the date of the advertisement, there was no relaxation.
No relaxation but the defect of state, that's why I'm pointing this.
So,
State government will not, the appellant rather have argued, I am told, that this defect was removed because of the subsequent amendment. I want to show that defect was not removed by subsequent amendment.
দেখি এটা দিয়ে দাও জজের শেয়ার এটা একটু দেবেন আরে ওই অ্যামেন্ডমেন্ট এবার
Kindly amendment brought on 9th of August 2017. That it shall be deemed to have come into force on the first day of April 2015. Therefore, the act was given retrospective effect vis-a-vis 1st April 2015, not beyond that. And then it says, provided further that every teacher appointed or in position as on 21st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children Free and Compulsory Education Amendment Act 2017. Therefore, the persons who were in a position on 31st March 2015, that is the retrospectivity. Here the notification is below June 26th of September, sorry, not June.
September 26.
Therefore, the persons who were not qualified, they were not in a position as on 31st March 2015. If they were appointed, then they have to acquire qualification within 4 years.
Relaxation নোটিশটা করেছেন শেষ প্যারাগ্রাফে বলা আছে ইভেন যাদের রিল্যাক্স দেওয়া হয়েছিল ওই টাইমের মধ্যে তাদের 2 বছরের মধ্যে ট্রেনিং পাবে এই তো এই পেজ নাম্বার 99 ভলিউম 1
Come to me, the original relaxation given at page 99.
Page 99.
Yes. Now, this was a notification by which relaxation was granted. And my lord will take the trouble to come to clause 7 and subclause Roman 6. The state government got it.
Page 99.
9.
It is a part of the.
Yes, but this is I'm referring to the clause 7.
Of a notification.
Yes.
Of 1st April 2020.
Right.
Uh.
This is the first where the Right to Education Act describes qualification.
Data page. Yes, what your argument?
Kindly come to me, Roman 6 of clause 7.
6 years.
The state government and other school management shall ensure that teachers who are appointed under relaxed qualification norms acquire the minimum qualifications specified in NCT notification within the period of 2 years from the year of appointment. This relates to the persons who were appointed by virtue of relaxed qualification. They were mandatorily required to earn the qualification.
This is before the.
This is before. I'm just saying, therefore, relaxations are always for a particular period to ensure that the people may come up with their training qualification.
Then what happens to Rule 6?
Ru-
Then what?
Rule 6 becomes
There was no such.
Rule 6 becomes redundant. No prayer is called for. With notification, now the notification is at a point of time.
So you are now challenging the rules also. Having participated, you are now challenging
I am not challenging, I am not explaining the effect of rules.
that it is a redundant provision according to you.
According to me, the notification was issued at a point of time when their relaxation was not available. Rule was made at a point of time when relaxations were available. I am trying to interpret the law in the context of the relaxation granted by the central agency. My lord will read Sukh 3 at a point of time when the rule was promulgated, when relaxation was valid. They ought to have completed or ought to have invited the application within the validity period, which they did not or could not. When you publish the notice, then there is no provision for relaxation. Therefore, Rule 6.3 automatically becomes non-applicable.
Doubt was not there in the recruitment.
Yes,
Participated.
it was. It was. Kindly come to Milord paragraph 9. Milord, I have started saying, Milord, this is a constitutional court. This is not, Milord, civil dispute between two parties. Milord, kindly come to paragraph 9. I am reading out. Well, I had placed it.
Intention is when the advertisement was published, when the rule was published in March That was in March, 2nd March 2016.
Then the relaxation period was valid till 31st of March 2016, sorry. They could have immediately invited application.
Promulgated validity was there. Because it is within 31st.
Yes.
At the time of advertisement, there was no validity.
No validity. That's problem.
As such, 6.3 becomes redundant.
It's not applicable except with that notification. I can't say redundant. If that was issued within the period, it was valid.
এখন রিক্রুটমেন্ট যেটা এখন ওই রুলেই হচ্ছে কিন্তু ওটা রিটার্ন না 2020 টাইমে 2020
Now, my lord was putting me whether there was any pleading. Yes, kindly come to me, lord.
Paragraph 9, no relaxation.
Right.
9 and 19
9 and 19 both.
Yes.
And this was never dealt with in the affidavit subject to correction.
No, not dealt.
Not. Now, these are the foundational facts. I don't trouble you lot anymore with facts. And I have not placed the affidavit filed by the agency. Now, the agency says, Ashbu, are what করছো কেন?
Yes.
The agency says that aptitude tests and other things were done by TPSCs at the district level. That's their affidavit. Was any legal existence of DPSC then? Now, beloved, kindly see the constitution of DPSC.
রিপোর্ট আছে আপনারা বার করুন
Page 31.
So on the date of the at the time of application, there was no.
Now, kindly come to me, Lord. Chapter 6 of the Primary Education Act 1973. Roshabde dao.
দিদি
It is latest too.
হ্যাঁ একদম
So kindly come to me, Lord, section 37, the primary school councils. District primary school council, state government shall, by notification established for each district excluding the hill areas and the areas included in Calcutta, with effect from such date as may be specified in the notification, a district primary school council bearing the name of the district and for the subdivision so and so. Provided that state government shall by notification establish for the subdivision of Shiliguri, I am not troubling my lord, then a district primary school council shall consist of the following members. But all these categories are mentioned. On that date, none of these categories representation was there. What was there? Kindly come to subclause K, chairman to be appointed by the state government. Now the chairman to be appointed in a